Good morning. This is a mediation in the case of Jonathan Cash versus Pennsylvania Tube. I reviewed the file and it's regarding an October 15, 2010 low back injury with surgical intervention. There's currently a claim petition pending before Judge Cigna, and we're here today to see if a settlement can be reached between the employer and the injured party. It may be beneficial to both parties to try to resolve this claim without going to a decision. For you, Mr. Cash, there's great risk involved in going to a settlement. You have about 2 years of benefits pending before the judge right now from the date of injury, and if you're successful, you'll obtain benefits at the rate of $845 a week for that time period, and also you'll receive all of your medical expense paid for. If the judge issues a negative decision, you'll get nothing. None of your bills will be paid for the medical expense, and you will be responsible for any co-pays, if any, that your private health insurance doesn't pay. Mr. Lafferty, representing Pennsylvania Tube, obviously you're aware of your liability. It looks like Mr. Cash is owed about $87,000 retroactive to the date of injury to this date, which is quite significant. So if the judge rules in Mr. Cash's favor, you have a pretty hefty amount that you're going to have to pay out front and obviously into the indeterminate future. So with that said, let's begin. Both parties know here today that whatever is said is confidential. Anything that we discuss won't be relayed back to Judge Cigna. It'll stay in this room. Attorney Lafferty, do you have your client available by phone?
I do, Judge. I also met with the adjuster earlier this week and have authority to negotiate on their behalf.
Well, I would assume that they would understand the liability up to this point, so we can look forward to that. Mr. Cash, before we start with the demand with your attorney, do you have anything you'd like to say?
Sure do, Judge. This whole thing has ruined my life. I mean, every week that I'm off work is another week where I'm losing money. With this constant pain I have, I'm not sure that I'm ever going to even be able to work like I did before. And I've always worked. I was hurt at work, and I don't understand why they're not paying me benefits. With this constant pain, I can't play guitar anymore. Quite frankly, Judge, I'm going down, down, down in a ring of fire.
I certainly understand your concerns, Mr. Cash. I'm sure this has had a major impact on not only you, but your family, and your whole future plans have been put on hold. Ms. Bailey, you've had an opportunity to speak with your client, and what have you come up with?
Well, first, Your Honor, I just want to say, Johnny, I understand that you've been through a lot with this injury, and it's been a very tough road for you and your family. And that pain and suffering is not to be overlooked. Unfortunately, in workers' compensation, you cannot recover for that type of experience that you have gone through. However, we have brought a third-party case against the company that manufactured that conveyor belt that caused your injury. And your pain and suffering will be a factor considered in that case.
That's good. I got a lot of pain.
Judge, before we go any further, I'd just like to say that it's our position that we stand a great likelihood of prevailing if we have Judge Cigna render a decision. This was an unwitnessed injury. The claimant testified that he knew that there was a policy requiring him to report the injury when it happened, yet he chose not to follow that. Furthermore, at the first hearing, he testified that he had no prior low back treatment when it was obvious from review of the medical records that he had been treating up until the date, almost a week before the injury occurred. Judge Cigna is likely to find that his entire testimony was not credible and to deny the claim petition outright. We do acknowledge that he's unlikely to ever be able to return to his pre-injury job, and therefore we're willing to negotiate. If we can get him to resign and get on with our business, we'd be willing to do so here.
Okay, I see some pros and cons with each side of the case as it's been presented so far. I've been a judge for a long time, Mr. Lafferty, and based on my review of the file, I think you should be prepared to settle this case. You know, I mentioned some back benefits that are payable, assuming Judge Cigna renders a favorable decision. Mr. Cash, you run the risk here of a negative decision. So I think it might be in the best of all parties concerned to try to resolve this. Ms. Bailey?
Thank you, Your Honor. And Your Honor was right. Mr. Cash's compensation rate is $845. That's the maximum benefit for an injury that happened in 2010. We think it is likely that the judge is going to find in our favor, as Mr. Cash presented credibly during his testimony. Therefore, in that regard, we are prepared to make a demand of $175,700, which is approximately 4 years of workers' compensation benefits. Plus, we are demanding that the employer and its insurance company waive the sickness and accident credit and pay any out-of-pocket or outstanding medical expenses related to his injury and pay the health insurance lien.
I tend to think that that's not a bad demand coming for a first demand from the claimant's counsel. I find a lot of credible issues in what I've read up to this point, but keep in mind, I'm not the one making the decision on this, but I do see where the claimant gave proper notice within 120 days. He filed his claim timely within 3 years of the date of injury. So I don't see those as being issues. There are some mitigating factors, though, however, with the medical. I'll concede that to defense. But I think there's a lot to argue there. So with that said, Mr. Lafferty, how do you feel about claimant's opening demand?
Well, I obviously think it's way too high. I understand that it's been 2 years since the injury happened and there's some potential back benefits that are accruing, but he's been receiving S&A benefits the entire time. We're only going to have to pay a fraction of those back benefits, the difference between the S&A and the compensation rate. We're certainly not going to waive our credit to that here or elsewhere. Furthermore, my clients they're not inclined to provide Mr. Cash with a windfall. These numbers that we're talking about here, he's going to end up making more money for being injured than he was going to make if he had continued working that entire time. In light of that, I'm prepared to offer $43,940, which is the equivalent of 1 year of benefits, which is more than he would receive even if he were to prevail in the claim petition.
May I, Your Honor?
Sure.
That's just absurd. A windfall to the claimant. His average weekly wage is $1,300 a week. He is, under comp, only entitled to $845 a week. There is no windfall to be had by Mr. Cash for getting injured. Once we win the claim petition, your client will have to pay Mr. Cash $845 a week until you decide you think that you can do something else.
Well, once you win the claim petition, we'll make a light duty job available as soon as we get that petition, or we'll send him for a labor market survey, or we'll fund employment down at the Goodwill. We won't be paying any benefits past the date of that decision. I can guarantee you that.
I can't work light duty.
Yeah, and that's another thing. You may think that you can make work available for him, but right now he has not been released to any type of work. Therefore, your client is on the hook for $845 a week. And should down the line he be released to some type of work, because there's no evidence that he's going back to his regular job, a labor market survey with an average weekly wage of $1,300 isn't going to significantly reduce your client's liability at all. Therefore, that said, we can reduce to $163,000 to resolve this case. But that's it.
All right, Mr. Lafferty, you heard the reduction of $163,000, which I think, given this situation, seems pretty fair. If you're not prepared to pay any more to resolve this case, and it doesn't appear that you're willing to do that, I would suggest that this go back to Judge Cigna to render a decision.
I agree with that, Judge. Based on the conversation I had with my client earlier this week, we're never going to get in the same ballpark here.
Well, I think you should have another discussion with them, but for the time being, we'll adjourn this and put it back in front of Judge Signa. Thanks for attending.
Thank you,
Thank
Judge.
you.
All right.